again, thank you for joining this live this live Facebook webinar on the topic of child custody and child maintenance. Once again, I thank those participants that partook in the live Zoom webinar yesterday, as well as the participants who have posed questions live on Facebook Live. Thank you very much for that. A bit of housekeeping. Please remember, I cannot see any comments or posts made on any other page other than the Advocate Mohammed Abduroaf Facebook page. You can see it on top over there, www.facebook.com// Advocate Mohammed Abduroaf /live, or you can make use of the link www.abduroaf.co.za /live. It redirects you to the other link. Please make use of that. If you have any questions, if you do not have any questions, that is fine. You can join in and watch from wherever you are, but we do advise you to like the Advocate Mohammed Abduroaf Facebook page for the sole reason we are streaming from that specific page. So you'll have first notification of whatever videos are streaming. These webinars are very interactive. You pose your question, I'll be able to see it. There's no questions now. You can see there's no comments above. The moment you pose a question, no one can see who you are really, unless they are on the page. And I will copy that question onto the screen on my left-hand side, the document stipulating live Q&A and with today's date. And we can all see it, and you are welcome to pose any additional questions or provide any additional comments after I dealt with the question. So try to be as interactive as possible. And I see we have one question that came in. It's on my phone in front of me, but is it on? Okay, I see it. It is on the live Q&A. Let's get to the question. Let me copy that question onto the screen. And if you have any additional questions, please feel free to pose it. I'll be happy to answer it. So this will be question one. If question one, commenter on question one has any additional questions, I will just copy it underneath that. I presume we all can see on the screen what the question is. It is as follows. Hi Advocate, what can parents do if a social worker is handling a matter in a biased manner? One parent and the social worker are and have been friends outside the case. Thank you. That's the first question. I see another question also came in. I'll deal with that question after I dealt with this. But I see question one, he added additional comment. I think I might have to deal with that first. Let's put in that additional comment. Okay, that's the additional comment. The social worker is making suggestions that fit the wants of the one parent's needs. And is there anything else? No, that's nothing else yet on that. And let me just copy question two. Otherwise, we might lose that one, lose focus. Okay. Moving from one screen to another screen can be a bit challenging. And there's question two. So let me just deal with this first, and I'll later on deal with any additional comments. So the questioner says the social worker is biased. What can he do? They're friends, the parties, the social worker and the other party, one of the parties, they are friends. And he goes further, the social worker is making suggestions that fit the wants of the one parent as needed. Now that's obviously problematic because a social worker, when dealing with a matter, and I presume this is obviously a child custody matter or some dispute regarding parental rights and responsibilities, has an obligation, professional obligation, to be unbiased. He or she should apply his or her professional opinion on the matter and not be swayed by personal prejudice, personal judgments, and at the same time knowing someone, one of the parties. So under these circumstances, I would, if I was a social worker, and this was probably the best thing to do, is to recuse yourself from this matter and say, I cannot deal with this matter in an objective fashion because I know one of the parties, I'm friends with one of the parties, and let's say I have to find against my friend, there will obviously be, negative consequences regarding friendship. I think you follow where I'm going to. So you will be limited to your decision. You might say, oh, I want to find against my friend, but if I find against my friend, he or she might tell my other friends, and then I'll be unpopular and so on. So on that basis alone, the person has to recuse his or herself. My suggestion is, to the commenter, is to ask the social worker, please recuse yourself from this matter. You do know one of the parties, you are friends, and it's clear that your decisions are in line with the ones of your friend. Even if it's not in line with the ones of your friend, you feel that there is some type of unfairness, unjustness, and there is a reasonable apprehension of bias in this specific case, that you will believe, you are confident that the specific social worker will find in the favor of the other party or be sympathetic to the other side. And that becomes problematic, because how can you successfully or in a meaningful manner engage with a social worker or a professional if you feel that the specific professional is biased and will not find, or and will not make a fair and a reasonable decision on the specific matter. Therefore, under these circumstances, ask the person to recuse his or herself, maybe stipulate it in writing, send an email to the party and also copy the other party in as well. Send an email to the social worker and copy the other party in as well. And if the matter is before court, also file that specific letter or document with the court and tell the court, this is your concerns, this is how I feel. I do not feel that I can, in a meaningful manner, deal with the specific social worker. I hope that answers the question to a certain extent. Question number one, you're welcome to pose any additional comments now that I have given my view on the matter. Let's us deal with question number 2. What happens when one takes a retrenchment package after serving court papers? No court order yet, can apply for future maintenance. I would obviously want to ask the question, are we referring to parties who are married to each other, income into property or out of into property, with accrual, without accrual? That could possibly play a role. Or the parties not married to each other and the one party is getting a pension payout and there's no maintenance order in place. So I presume we're doing maintenance here, but the commenter could possibly add some additional information, some background information. Where are we going to? Because you are entitled to take a retrenchment package after serving court papers. What type of court papers are we talking about? Divorce court papers, maintenance court papers? I do not know. Maybe add a bit of comments and I can give you more of a meaningful answer to that. So I'll hold that. If I do not get additional comments, I will come back to it and I will try to answer it on basically on various scenarios. I have a third question. Let me just copy it in. Okay, got it. It seems to me the best way to do this is a manual way. Use a mouse and copy, not Control and C and Control and V. There we are. Third question. Morning, please advise what can be said to MO, I would presume the maintenance officer, who is telling parties that because one party is unemployed, the expense of the child should be split in a 50-50 ratio. Now, let us maybe go to the basics first. Maintenance is not payable 50-50. The law doesn't say that. It's almost like saying if a child costs, for example, 1,000 Rand, I'm using round figures, and another parent earns one of the parents earns 500 Rand, and another parent earns 10,000 Rand. Then we're basically saying if it's 50-50, the one parent, all his or her income must be used for child maintenance, and the other parent must only use 50 Rand of his 10,000 Rand towards child maintenance, if I remember the numbers correctly. That will obviously be unfair and unreasonable if you go on a 50-50 ratio. Same would, for example, apply the child costs 1,000 Rand, but one parent earns 2,000 Rand, so he must pay 1,000 Rand according to this logic. And the other parent who earns 100,000 Rand per month, he should also pay 1,000 Rand. So one parent pays 50% of his or her income, and other parent pays, how much is that? 10% of his income. Sorry, 1% of his income. Now, be that as it may, whatever the circumstances of the case, we need to make a fair decision when it comes to maintenance. Now, maintenance is applicable or payable according to your means and proportionate to your means. And at the same time, someone can be earning nothing, be unemployed, but he or she owns a great amount of assets, is extremely wealthy in the sense of assets-wise, owns few houses, lots of cars, but has no salary per se as such. But the one parent, the other parent earns a salary of, let's say, in this case, 2,000 Rand per month, the child costs 1,000 Rand per month. You can't say I am earning nothing and therefore I can't afford to pay. So, because you have assets, that basically applies generally how maintenance is calculated. So my advice to you, the Pacific commenter, is unless you have a lot of assets and the court considered your assets, then the court could be right, it must be 50-50 because the one party earns X amount of money, but you have a lot of assets and you are unemployed. But if you are unemployed and without any, significant amount of assets, the usual assets which people generally have, the same like the other parties, what the other party has, then maintenance should not be split 50-50. It should be according to your means. Because let's say, for example, you are not unemployed. You earned half the other person's salary. Then the law, certain specific maintenance officer would apply the principle that you should pay 1/3 and the other parent should pay 2/3. But here you do not earn half his salary, you earn none of his salary. So obviously 2/3 or 1/3 will be impossible. But you earn nothing, so automatically the amount should be less. It can't become more. It's like saying somebody earns X amount of money, you should pay little maintenance. But if you earn less than that amount of money, you should pay more maintenance. And the logic doesn't make sense because there is no money. You are unemployed. How can you pay that 50%? So there is no logic. The child requires 1,000 Rand per month. That's my example for now. The maintenance officer's logic is, because you're unemployed, you should pay 50%, 500 Rand. And the other parent should pay 500 Rand. Where must your 500 Rand come from if the other parent can afford to pay that? Unless possibly the other parent cannot and can only afford to pay that 50%. And then, unfortunate for the minor child. And then we have to maybe go to the grandparents and look for money from them. So I think the bottom line is, regarding the law, you must probably just have to go look up some case law, Google child maintenance amounts, some cases, how the courts dealt with that, and address that to the maintenance officer, or maybe to the maintenance magistrate, or speak to somebody in the court, maybe a maintenance prosecutor, for them to try to explain to the maintenance officer that that is the specific law and that is how it should be applied. If the party can only afford the 50%, the other party, then that is a factual thing. And then unfortunately for the child, that the other parent doesn't work. The unemployed parent must make a plan. However, nonetheless, moving forward with a specific thing, look up the law, find out how the law works, have a discussion with the maintenance officer and see what he has to say. But at the end of the day, if he makes a silly order, remember, he can't make the order, sorry, my apologies. The maintenance officer cannot make the order. He only deals with the administrative aspect of the case. It is the maintenance magistrate that makes the final order. Address it to the maintenance officer. If it doesn't work, you have to address it to the maintenance magistrate. But however, the entire process still needs to take place. There still needs to be an inquiry. how much the child cost, what is your income and expenditure. Of course, it's zero your income. Then the court has to determine, you need to explain to the court how do you survive, and same with the other party. The other party has to do exactly the same. So I hope that gives you a bit of a nutshell, a general understanding on how these type of things work. I see question number 2 added some additional comments. I'll be happy to copy that quickly in. I think my query was what court applied. That's the first comment I see. And here's an additional comment. So let us make this as interactive as possible, so we can all learn and benefit. I also learn and benefit because I give my brain a chance to develop and to keep it moving. I have another comment, question number 4. Let me just quickly add that one in, so while I'm busy with copy and pasting. There it is. So let's go back to question number 2. What happens when one takes a retention package after serving court papers, no court order yet, and I can apply for future maintenance, divorced parents, is a child maintenance order. Okay, so the parties are divorced. There's nothing regarding the patrimonial property aspects. Here, one party is going to take out a retrenchment package, or maybe cash his retrenchment package. He took a retrenchment after I served him papers for maintenance in March. He is welcome to do that. The only way you can attach that specific money is if the person is not paying child maintenance. It is a sound reason for that specific person not paying child maintenance. Sorry, it is the only reason. Sorry, my apologies for this. The only time whereby you can attach that specific retrenchment package is if the other party is not paying child maintenance on time, he does not want to pay, or he refuses to pay. The maintenance obligations will obviously apply on a month-to-month basis. So as long as a specific person pays maintenance on a monthly basis, then there's no basis on which you can now attach his specific lump sum. It is his money. Regarding the specific retrenchment package, if there is any cash amount being paid to him, I presume there will be a cash amount paid to him, and this basically increases his wealth, his net worth, then the court can basically relook this whole situation. Because before he cashed his retrenchment package, his earnings or his net worth was a bit less. Of course, he had a package lying somewhere there, but his disposable income was less. Now he's cashing in on this retrenchment package, and he has more money available, more money to dispose of, which money can obviously or should be used for the minor child as well if the minor child requires that. So that is where the court can look at that. But he has full right to make use of his retrenchment package. He worked with it. The parties are divorced already. Life went on. If he does not pay the child maintenance, then we can ask the court, please attach this pension fund or interdict the retrenchment, retrenchment fund from paying monies to him, and they should pay the specific monies over to me as maintenance in lieu of the current maintenance order. So there needs to be a legal basis upon why you say the court must now attach or take this money or use this money. So going to the question, what happens if one takes a retrenchment package after serving court papers? Nothing. You can do whatever you want to. You are applying to the maintenance court for a certain amount of money. I presume you're applying to the maintenance court for an increase. He can do whatever he wants to do with the money. The same way you can do whatever you want to do with your money. Only if there's a problem and the court is afraid, or you are afraid that he will dissipate the money, then you can approach the court and say, please hold on to that money. We found some money. Please hold on to it and let the money be used as maintenance. Sometimes the mind goes a bit here and there because the screen is just moving up and down. So I hope I have answered that specific question. Let's go to question number 4. How do you prove that the other parent have extra income but the business is not registered? That is a very difficult question. My guess is just as good as yours. I can give you a lot of possible scenarios. One would be to speak to the person's clients, have an investigator follow this person, find out what the person's operations are. If the person has a bank account, have the bank accounts subpoenaed. Those are the normal stuff. I mean, this is a isolate. Every case is different. Every parent is different. Every business is different, and how the specific person operates is different. Some people, they run a business where they do one job per month, so it's one invoice going out and one payment coming in per month. Let's say they do big jobs. And some people, they do a lot of small jobs for the month, or maybe 200 of it per month, and they get paid most probably 100 Rand per job. So those are the variables that applies here. Some people work with cash, some people work with bank accounts, some people work with EFTs, credit cards, and so on. So what you need to do is you need to be creative. If you ultimately, what I'm telling you is, what I'm mentioning to you is, if you cannot prove that this person is earning extra income, and this specific person denies it, and there's no evidence before the court that he is earning extra income, then more than likely he's not earning any extra income. It's your allegation against his or hers, depending upon the gender of the parties. Therefore, if you have a strong assumption based upon facts, or there is information which you have seen while you were with the person, while you were living with the person, or what people have told you, this person is operating this business, he's doing graphic designing, he's setting up websites, he's a taxi driver, he's an Uber driver, whatever the case may be. So there you have your evidence. Now you need to dig a bit further, and you need to now maybe get the assistance of the maintenance court. So if he's an Uber driver working in the evenings, doing Uber work, and he's earning some money from that, if he's a delivery guy who must delivery, extra income, whatever the case may be, you can ask the maintenance court to subpoena the Uber, Mr. Delivery, whatever it is, the bank statements, and based upon that, the court will know whether or not he is earning extra income or not. But generally, when you go to the maintenance court and you make these type of allegations, do your research first. And if you come to court with a strong allegation, for example, no, he works for Uber, here's photographs of him driving customers. I actually know of a few people that have, you'll say this, that have a use of his services, etc. And I found Uber, and Uber confirmed he works for them. So when it comes to the maintenance court or the maintenance inquiry, he won't deny it, he will admit it. But if you go to the maintenance court and you say, I believe he earns more money, I do not know, he'll most probably keep his mouth quiet. Or she will keep her mouth quiet, depending upon the facts of the matter. The same way, if a child does something naughty and you do not know what he's doing, you will obviously have to do research, investigate. You know, he or she might deny it. You have to find out ways of figuring out the truth. The same way with the maintenance matter. This is an income, additional income. There should be bank statements. There should be some type of proof that the person is earning additional income. And you need to find it. I hope that answers that. If not, if you are commenting now additionally, please just say question 4, question 3, question 2, so I know where you belong. Sometimes a bit difficult to connect the name to the question as the string goes further and further. But now we got question 5. Let me copy it over quickly. Copy. And there we are. Let us deal with this question. Is there any recourse a parent can take if the court loses the case file? An urgent application was made, but due to COVID, the matter was postponed for 1 day, only to hear the medical test need to be performed and returned to court. Upon return, the court claimed they lost the file. The urgent matter has now become just another matter and not handled in an urgent matter anymore. The urgency was based on drug use by the primary caregiver. Should the parent engage the court administrative clerk in a more aggressive, constant basis to find the file or start a new process? I feel that we are parents and children are not responsible for the court's administrative and operational process. This is a very sad issue and a very concerning issue because, you know, if court files are getting missing, there are original affidavits, original court documents in the court files. The court is a public building. People go in and out all the time. the files can easily get missing, and that's unfortunate. And if the files have gotten missing, it places the parties in a very difficult position, because you spend thousands of rands or hours, if you've done your own matter, on preparing, filing, serving documentation. It costs money also to do all of that in serving documents via the sheriff, emails, whatever the case may be. Now the lawyers are ready. We're in court, ready to proceed with the matter. The fees must be paid. I mean, the time is money. Court file is missing. Court says, I can't find the file. Everything else is stamped. On your side, you have proof that the documentation was presented to the court. The clerk stamped the court documentation the day before. Obviously, it was handed in to him or her, and so on. Court file is missing. There's nothing that can be done. Yes, you can give the court a photocopy of the file. I presume there is a photocopy, but then the judge never read through the documentation because the file was not handed to the judge, and everything is stalled for a day or two. One option you obviously have is to file a duplicate court file. Obviously, the principle would be always have photocopies available of all documentation that you file at court. But on the bigger question, you can obviously, if you feel that the court was negligent, the court did not do their job, in negligent in losing the court file and so on, you can, and you suffer damages, you can sue the Department of Justice for not doing a proper job because of the damages you suffered. They had a legal obligation to ensure that the court file was taken care of while it was in their custody, and because of their negligence, whatever the case may be, it's all theoretically I'm talking now, not specifically say it applies to your case, but theoretically, you can prove to the court that due to the Department of Justice's negligence, you have lost out or incurred certain damages, and they must compensate you for that. It will be a very interesting case. I never heard of any such a case before, because I went to court so many times over the years, and so many times duplicate files had to be opened because I can't find a court file. Files get issued, it goes in the pigeonhole behind, at least I'm referring now to my local courts. It goes into the pigeonhole. Anybody can come later and say, oh, that's my file, let me have a look at it. While they have a look at it, the clerk is busy with another 100 people. You would have forgotten about. The person can walk out of the court with a file, put it in a bag and walk out. Nobody will know. Maybe there should be cameras, maybe there should be a more stringent way of dealing with these type of matters. So I hope that specifically assists with that specific query. Depending upon the nature of the matter, you might have to decide to file another application, depends on the facts of the matter. The question is, should the parent engage the court administrative clerk in a more aggressive consent basis? If the file is missing, the file is missing. There are thousands and thousands of files in the High Court, tens of thousands of files in the High Court that are being issued. Thousands of files are being issued on a yearly basis, but there are tens and thousands of files in the High Court, maybe a million, I don't know, I do not know. If that file is laying with anybody else's file, let's say the clerk came and came to collect a certain file, but took your file by mistake, and in some judge's office on the 3rd floor, and it will remain there maybe for the next 3-4 months. So the file is most probably missing. Duplicate files are very useful, and if the court is willing to issue a duplicate file, that will most probably be your second best guess. And obviously, suing the Department of Justice if you feel that you have been strongly aggrieved and you have suffered damages. I never saw such an action before, but you can consider it. I see no additional questions. If there are any additional questions, please feel free to pose them. We are now past, let's see the time. From a recording time now, I record these videos from the moment I started, so I can put it onto YouTube later on. It's 28 minutes. That's a lot of time. If there are any additional questions, please feel free to pose them now. Otherwise, we'll conclude this video. We will have another one again tomorrow morning. I cannot say exactly what time, because with this COVID-19 and everything, you do not know how your schedule goes. We are busy with another court case, a custody battle for the last few years. The matter was heard last before COVID-19. Things were still fine. I think it was in February. And then the matter got postponed for the other party to get legal representation. COVID-19 came in. Now we're back in court a year later, on the same facts, on the same reports, just because of this COVID-19 challenge we had. I see another question coming in, and it's concerning because you do not know how to deal with these type of matters. Unless you keep an eye on them all the time. We had to confirm with the judge, are we being heard virtually? Is the matter being dealt with in court? All important things to do, but it's a different world in the litigation world. So you do not know what happens, what to expect the next day. Generally, I will start high court litigation or high court proceedings at 10 o'clock. So I leave my chambers at about 9:30, get to court, introduce myself to the judge if I never met the judge before the time, and so on. Now, those have been suspended. You do not meet the judge before the time in the chambers, even if you never met him before, to limit the spread of COVID-19, which is all fair and reasonable and correct. The challenge comes, of course, in knowing how to deal with your day. Sometimes you prepare to appear before a judge in court, but then you get a notification that the judge is dealing with the matter via Microsoft Teams. So that also puts a bit of a challenge, but it seems to me that it's working very well. Okay, the last question, I guess, but however, feel free to pose any questions. I'll copy this quickly. Question number 5. Question number 6, sorry. We'll stop there. There we go. This is a two-part question regarding maintenance. Can a parent provide physical items, formula, clothes, food, etc., instead of transferring currency? I think that's the first question. If so, will this method not lessen the rampaging parental alienation issue in the country by using this method to keep the parents in contact with the minor children? I would say that's a good idea if the parents are fine with that. The difficulty with such a scenario, if it's not workable, is that we have this constant communication between the primary caregiver and the secondary caregiver, whereby they will have to, if the parties are acrimonious, the parties are not friendly with each other. And now the mother says, for example, I'm using the stereotype example that the mother is a primary caregiver. She says, I require X, Y, and Z, right, for the minor children. Clothing, food, etc. But how does she work the food out? Because she can't only 3 potatoes for the minor children, but then she needs to add, because there's 4 other people in the house, let's say new kids and the step parent. How do you work that out? And what if the bill comes to, let's say the maintenance order is 500 rand per month, and now she says, no, I require the following, and now the bill comes to 800 rand per month. Does the father only buy 500 rand worth of groceries, or the last week he says, no, I'm not buying any additional groceries? What if the mother does not want to make peas food and the father's buying the peas food all the time? And she'll say, I mean, we can't eat peas food all the time. So if there is an understanding, wonderful. If there's no understanding, it does make logical sense in my view. If you just pay the one parent the maintenance, and that parent is supposed to use that maintenance, then you deal with the issue of control, because parties are separated, they divorce, they move on with their lives. Where one parent got to always be involved in the other parent's life. So every week, email his ex-spouse, here's this, and if there's a dispute, they start fighting. And I don't think that is in the child's best interest. In my view, my professional view, not my personal, my professional view is, you pay the maintenance, the other party will have to use it. 1 month, let's say you pay 1,000 rand per month, but the kids are now, for example, not so much at home, and she only uses, for example, 800 rand for the child. But the next month, the kid eats more. Then she will use the 200 rand of the previous month for the next month. They need parties who are acrimonious. They should not have to communicate on issues concerning the child. Tomorrow the mother says, I needed some more potatoes. I couldn't get hold of you. I bought another kilo of potatoes. Then the other parents said, bought the potatoes. Say, no. You should have contacted me. Or I bought a lot of potatoes last week. All these type of challenges comes about. We have one parent who is actually caring for the child, who knows exactly what the child requires on a day-to-day basis, and another parent from the sideline who's not so actively involved in the child. That is if it doesn't, if they're acrimonious. And having such a clause in place stipulating that one parent should purchase certain items can just cause more problems. But if the parties are fine, the marriage has broken down, if the relationship has broken down, and they WhatsApp each other, they have an understanding, wonderful. That is perfectly fine. You know, things like school fees, those are simple things because those are monthly expenses or yearly expenditure, and all that the parent has to do is just pay it. School fees, extramural activities, and so on. Those are easy to resolve. But when it comes to these groceries and food, is a bit hard. Clothing as well can be difficult because a primary caregiver will know exactly how much what the child requires. Um, like sizes. I mean, who's to do? You know, take the child to the store. The other parent, that's fine. If they're happy with that, that's fine. But however, if there's issues between the parents, because now the dad buys the daughter a nice miniskirt, and the mother said, "How can my 16-year-old daughter wear this miniskirt?" You know where I'm going to. And the commenter says, "Thank you, advocate. Appreciate your advice anytime. You are all welcome, and thank you very much for your questions. We have 6 questions, and I think that is it. If there's anything else, please pose it now. Otherwise, I'll have to end this webinar in the next minute or two. That is it, guys. I appreciate it very much. I hope to see you tomorrow online again. If you have any additional questions, please feel free to pose it on the Advocate Muhammad Abduroaf Facebook page. I hope you can, yeah, you can't see it on the screen. You see something on my right hand side, but you can't see the finer details. Just type in the Advocate Muhammad Abduroaf, not my personal page, but the Facebook page. Have a lovely day further, and I'll see you tomorrow sometime online.